The title of this talk is Global Law in an Anglophone World. It was presented at the Swiss Center for International Humanitarian Law. It was published in Switzerland by the Journal of Global Processes, then republished in 2019 by Pestalozzi University Press, edited by Craig Peterson. I will read a portion of the introduction. The project of globalization is often thought of in terms of technology, commerce, communication, and travel, but it has an important legal aspect as well. In fact, all of the great advances in technology, the ability to transmit sound and image, the ability to transfer and store information, to trade and travel across great distance, all take place within an atmosphere defined by law and against standards of legal oversight and regulation. More than that, every one of the technical advances has emerged from a process of research, patent, copyright, finance, and incorporation. Each of these steps shape their eventual use and impact on the world, and each of these steps is legal in nature. Moreover, governing structures that are being assembled to tie all localities and peoples together into a single seamless unity around the world are constructed on foundations of law. Whether this involves the merging of nation states, treaty alliances, international organizations, or multinational corporations, all of these entities and initiatives are fundamentally legal creations. Their methods of oversight, governance, and regulation are done by instruments of law. Even those incidents of crime, terror, subterfuge, and warfare that may occur outside the boundary of legal constraint are defined as being prohibited and are investigated and suppressed by means of legal authority. However, in this proliferation of legal instruments and institutions, there are many challenges concerning how a global regimen of law should be constructed. For one thing, many national governments are involved, each of which has its own legal system. There is continuous debate not only over methods to solve immediate and practical problems, but there are also questions about how a global regimen should be framed, according to what standard, and decided by which body. It goes without saying that such questions and problems can become extremely divisive because they can involve matters of national interest or sometimes national survival. But even more than these practical problems, there are deep questions about what kind of legal regimen should be constructed and for what ultimate purpose. The central axis around which this discussion revolves is between the two great legal systems that developed out of the Western tradition. These are usually referred to as the continental or civil law on one side, and the English common law or Anglophone law on the other. Outwardly, these two legal traditions seem to have much in common. However, there are stark differences that divide them. Obviously, they both have courts presided over by judges, lawyers or advocates present arguments in both systems. A continuous production of legislation shapes the internal content of the work in both legal methods. In conclusion, One of the important differences between the two Western legal traditions is that the continental law is based on explicit principles and can easily be translated into any language. By contrast, Anglophone law is based on internal consensus among members of a juridic fellowship. It cannot be translated into another language. Thus, one importance of English as a global language was to make possible the English language tradition as the basis for a global law.